Now, the fight between India and the US over intellectual property rights has worsened. On the 30th of April, the United States Trade Representative will release the Special 301 report where India may be categorized as a serious IPR offender. But India is not ready to take this lying down. Rituparna Bhuyan joins us now with more details. Ritu, this IPR battle between India and the US has been on for a while now. What is the latest trigger and how is India planning to hit back? And if you can take us through a little more on what this 301 report really means.
Well, recently the Indian ambassador to the US raised red flags on the Special 301 report, which is released annually by the USTR's office. It's basically on compliance related to IPR-related laws, and the Indian ambassador to the US expressed concern that if there are any adverse comments against India, and if India is designated as a serious IPR offender, there could be trade sanctions. Based on this, the Cabinet Secretary had called a meeting asking government departments like Commerce about what could be the possible scenario if this happens, and all the government departments including DIPP and the Commerce had four broad messages. Firstly, Indian IPR regime is fully TRIPS compliant. Secondly, any suggestion related to directly engaging with US based companies, pharma companies on IPR issues, that should not be carried out. The third message was if needed be, India can engage bilaterally with the US government on any trade issues including IPR. That can be done. Lastly and most importantly, if US carries out trade sanctions based on adverse comments in the Special 301 report, then India can drag US to the WTO. In fact, sources in the Commerce Ministry have told me that the Commerce Ministry has already carried out a study on this on any adverse remarks in the Special 301 report. According to Commerce Ministry, 301 regime is actually not WTO compliant, and India is actually ready with its defense as far as the Special 301 report is concerned. So now we'll have to wait and see what happens on 30th of April when the USTR's office releases this much awaited report. With that, it's back to you.
All right, thanks very much for taking us through the latest development, the IPR battle between India and the US versions. For more on this, we're joined by Senior Advocate Pratibha M. Singh. Pratibha, appreciate you joining us here on India Business Hour. You just heard what Ritu had to say. This, in a sense, is hardening positions on both sides. The Indian government has always maintained that we are TRIPS compliant and we will not take lying down any adverse comments from the US or US-based companies as far as IPR issues are concerned. And now, if indeed India has declared an IPR offender by the US Trade Representative, where do you really see this headed?
I would think that this is a very serious issue, in as much as this provision of IP law of Section 3D or compulsory licensing has existed on the Indian statute for many years. And so a judgment of the Supreme Court or the Patent Office or the judicial authorities of this country cannot be treated to be kind of violative of any laws as long as we comply with the statute in India. And therefore this would impinge on India's sovereignty in the sense Supreme Court is independent of the government, quasi-judicial bodies are independent of the government, therefore they decide as per the laws which are existing. Therefore I think that this would be a very serious matter both for the US and India, and it would be very unfortunate if this in fact happens, because as an IP practitioner, the way Indian judicial authorities are extremely pro-IP, they look at IP completely dispassionately and they give fair orders, and I don't think that India is in any way violative of TRIPS.
Okay, but let me ask you this, Pratibha, and I want to put out a disclaimer that you represented CIPLA in the CIPLA versus Novartis matter. But, as Ritu was pointing out, that the government is preparing to take this matter to the WTO if indeed on the 30th of April India were to be called an IPR offender by the US Trade Representative. Do you believe that India has a strong case if we were to take this matter to the WTO?
See, IPR does not involve only pharma patents. IPR involves the entire gamut of intellectual property rights, starting with trademarks, copyrights, trade secrecy, software, books, movies, patents. and even non-pharma patent litigation. And therefore, one aspect where some particular group of industry has an issue cannot make India an IPR offender. It's at best a negotiating point. We need to talk, and this is not the time to have something such a serious thing as an IPR offender. I think that's too high a charge against India, considering the present IP vibrant atmosphere that India has. And I think India has an extremely strong case.
Yeah, do you believe, Pratibha, that this is really, pressure tactics, that perhaps at the end of the day, come the 30th of April, we won't find ourselves in that 301 report as an IPR offender, but this is really pressure tactics by the US. We've, of course, seen publicly how US companies have been lobbying with the US government to try and get India to kowtow or bow down to the kind of demands that they would hope to see as far as the IPR and patent regime is concerned. Do you believe that these are pressure tactics?
Please understand one thing. Insofar as IPR is concerned, the statistics will show, any amount of case laws, etc. will show that India is pro-IP. However, this Section 3D against which the US pharma companies have an issue was enacted on the floor of Parliament. And therefore, if Parliament had enacted Section 3D, to challenge that section and to put pressure would be completely impossible for India to achieve in 10 days. And therefore, this is a point where I think there needs to be a proper negotiation. There is a huge misunderstanding. There needs to be better understanding of issues. Rather than kind of putting a unilateral viewpoint on India, there needs to be more understanding on both sides.
Pratibha, before I let you go, I also very quickly want to get your comments on the story that we've also been tracking, in which is the Supreme Court cracking the whip as far as clinical trials are concerned, accusing the government of a casual approach. This takes forward what the Supreme Court had already said as far as clinical trials were concerned, to make the whole process more transparent. It had set up a three-tier system. Now it's saying that the government needs to put in more stringent parameters and very clearly defined parameters. What do you think this is going to imply as far as the pharma industry and the clinical drug industry is concerned?
First of all, we need to understand what clinical trials are. Clinical trials involve giving placebo, which is a non-medicated product, and the drug itself, which is going to be tested on healthy and unhealthy human beings. Therefore, the first thing that needs to be done in a clinical trial is to get consent of the patient. And from what I understand from the stories, there is no consent taken, then that's basically violative of all kinds of clinical trial regulations. Therefore, there needs to be a proper guideline which is to be followed, and I'm sure India is already prescribed these guidelines, but these should not be violated. And if there are any violations, then they should be taken extremely seriously. And if Supreme Court has pulled up the government on this, I would think that that's the right thing, because the Supreme Court has to see as to how clinical trials are being performed on patients who do not know the effects of these drugs. And therefore, there should be a proper compensation regime. Yes.
All right, Pratibha, we will have to let you go. Thank you very much for joining us and giving us your comments on both those stories. Appreciate your time here on India.